do record. So we record meetings for people who can't attend. I probably should have asked if everyone was okay with that before but we tend to do it as practice, so I hope that's okay with everyone. Don't worry, it's not going to be used for anything other than our own kind of, yeah. Um, I doubt anyone else will be tuning in. Yes. Is my Wi-Fi okay? Is it okay? Okay. If there's any kind of, reverb or kind of funny stuff happening, do let me know. Yeah. Okay. And then Jeff, I'm just going to mute you just because there's a bit of noise. Is that okay? Don't mean to. Yeah. Okay. So, just going to let a few more people in and then yeah. Okay, I think we'll start. So really warm welcome back. We've had a month off. It feels like longer. So I'm Geo Yotzi and with Ali White and also Vasily from the Bristol Tree Group, and I can't remember Christine, who's not here currently. She's probably coming in from the Sheffield Tree Group, and John also from the Bristol Tree Group. We make up the kind of new committee of the Canopy group, which is very exciting. So we slightly formalized ourselves, but we're still lovely and informal. So don't feel any kind of, we're all tree lovers, and that's our main thing.
Never to be formal.
Yeah, don't worry about being overly formal here. Although obviously we can't, can't quite do exactly what we want. But so we've sort of formalized ourselves. How long have we been going now, Ali? A couple of years. I can't actually remember. Is it our second year? Yeah. Anyway, don't worry.
Year and a half, I think. We're about a year and a half.
Year and a half. So we're the National Tree Coalition of Tree Groups, and we're growing all the time, which is fantastic. So tonight we're going to have updates from new people. So for those people we kind of know, we might leave any other updates to the kind of after we have our speaker, who's Sarah Dodd from Tree Law. So for the first half hour, we're going to be hearing from some new people. Chris from Save Wimbledon Park. Are you here, Chris? Yeah, there you are. Lovely, welcome. And Sally from the Chidswell Action Group. Is that right? Where's Sally? Is Sally here? She may not be here yet. So we're going to hear for a few updates from new people. And yeah, then we're going to, then Sarah Dodd from Tree Law is going to be coming on and speaking for about 15 to 20 minutes. And then we're going to, we'll have a Q&A with her. So anything to do with the law legislation surrounding the protection or the lack thereof of trees, have some questions ready. If there are any particular cases or any particular questions that are pertinent to your own, perhaps tree battles or campaigns, do feel, feel relaxed, feel comfortable asking, and also possibly about the public duty to consult. I may actually have a few questions about that myself. I will also be updating on our Oakfield plane tree, which has come to the fore again, rather tragically. The tree we've been trying to save for 3 or 4 years now. But I'll let others go first, and I'll probably, update after Sarah comes on, kind of thing. So lovely to see some new. Who is actually completely new to the group? Do you mind just putting up your... Okay, so I have Penny, Chris, Gordon. Let me just write down so I actually remember, because you're the people who... So I've got Penny, Gordon, Chris, who I've mentioned, Julia, Rob, and who... Was there someone else who put their hand up? Kit. Was it Kit? Janny?
So I think it's Janny, who is also, I and Janny are coming from Friends of St Matthew's piece in Cambridge.
Oh, brilliant. Okay. And Valerie as well. Okay, great. Yeah. Okay, so perhaps one of you could speak when we do the updates, but let's just start. Let's just begin before Sarah comes in and invite as many people as we can. I would say I'm going to put a kind of timer on it, so you know, 5 to 10 minutes is probably, you know, kind of, if some people would be shorter in terms of their time, other people might want to share a bit more. But I think, Chris, you had some slides, is that right?
Yeah.
Okay. So I think we'll just start, and I'll keep an eye. Could someone else possibly keep an eye on the time at and remind me of 6:30? I mean, I try myself, but so Chris, welcome. You're from the Wimbledon Save Wimbledon Park group.
Yeah.
Is that correct? And I think you should be able to, if you've got slides, you should be able to share your screen. Do you want to try that and sort of see if you've got that function there? Otherwise, I can give you that authority to. Yes, there you go. Great.
Right. Can everybody see
Great. Yeah.
that?
Yeah.
Yep. Can you see it says ALTC Wimbledon Park development since 2021
Yeah, that's great.
and the picnic basket?
Lovely. Yeah.
Okay. Shall I make a start?
Yeah, go for it. And I will I'll give you sort of probably 10 minutes. So after that, yeah. Okay.
Okay. We are a campaign group in Wimbledon, which has given its name to the All England Tennis Development, which has been going on here for probably 150 years. This is about the All England's development into the adjacent Wimbledon Park. The proposal is to considerably change the layout of the whole park. On the left is something that's somewhere else because this hasn't started, but we're bothered about thousands of cubic meters of earth being moved, removed, the felling of at least 300 trees, loads of hedgerows and scrub being moved, lots of concrete, and a lake being desilted. The whole point is this was a Capability Brown Grade 2 star registered park and garden. It's metropolitan open land and it's green belt. I thought those of us old enough to remember Joni Mitchell or young enough to remember it again might enjoy this one. This is a quick outline of what they propose to do. I don't know if anybody's been to the Wimbledon tennis. To the left of this map is the existing tennis complex. To the right of it is the new development in the parkland. The red routes are roads, 9.5 kilometers of paving. Huge purple blob in the middle is a massive stadium, 8,000 seats, same size as the Albert Hall. 38 other tennis courts, all of which are beautifully constructed with concrete bunds. There may be some trees left. You can see vaguely grey sort of outlines of a lot of the Capability Brown veteran trees. But what's significant to us, and that's significant, I hope, to this group, is that on the existing All England site, there isn't one tree. It's a big tennis complex with lots of nicely manicured grass and hanging baskets. On the right-hand side, they plan to keep some trees. Yes, maybe they will, but trees have roots, cast shade, have leaves, and wave around in the breeze. We don't think they're going to last very long. They made a planning application in 2021, and we've really enjoyed looking through 225 documents in 4 different attempts. We've mustered about 3,000 individual planning objections. We ran a petition against this. 22,000 people have signed that. It's in 2 London boroughs. Merton voted, frankly, along party lines, 6-4 to approve the application. Wandsworth, the other borough involved, turned it down 7-0. We thought those were the first 2 of the 5 set process we're in. It went to the GLA in 2024, and again, frankly, it appears on grounds which we didn't really understand. They gave it approval. We asked the Secretary of State to call it in. The Secretary of State wasn't interested and left the GLA's decision. So we're now embarking on judicial review of that decision. There are grounds relating to the planning. One of the most significant grounds relates to the statutory trust on which, as we now learn, we believe that the All England holds this residual piece of Capability Brands Park. And I've just outlined in this slide the reason why it's been so important for such a long period of time. During the 19th century, suburban London was massively developed when the railways arrived. The old estates, this was the Spencer, Althorpe, and Duke of Marlborough linked estate, were all carved up, sold off for development. And in 1915, the Wimbledon Corporation, which was then the local borough, bought it to preserve it as open space and keep it the golf course, which is what the All England want to do with it, to develop. That was to be kept. Merton Council was established when the local government was reorganised in 1965, and the entire estate was declared to be public trust land. I can go into that in a little more detail if anyone would like to. It's quite a techie legal thing. It was sold to the All England in 1993, the freehold, that is, subject to a lease to the golf club. And in 2023, we had the decision of the Supreme Court, unanimous decision, that in cases where land is public trust land, the council, on disposing of that land, have to undertake certain processes. And in the Shropshire case, they failed to, and the Supreme Court says in that case, the members of the public have the right to go onto land for the purpose of recreation. We believe our circumstances are bang on the same point. I mentioned that the All England had bought the land in 1993. The council was selling it off. It had been told to realise money from sale of public land at that stage. And there was a massive outcry, as you might expect. This is a cause célèbre and has been a cause célèbre for hundreds of years, frankly. So Merton Council promised they would keep it as open space, and the All England chairman said they will never develop it. Look what's happening now. So we've got three, and those of us retired lawyers just love it, or not. We've got three issues. Firstly, we had to challenge the GLA's planning permission of September last year. And our key question is whether that's a lawful planning decision. I can talk about judicial review and stuff like that in a moment. And we come on to go to the High Court on the 8th and 9th of July, which those of you who are tennis fans may realise is the quarterfinals, women's and men's quarterfinals for the championships. We think the TV is going to be rather interested in what's going on in the Royal Courts of Justice in the Strand. We've been raising funds for that case. It's costing serious money. We've had a lot of pro bono help so far, but now it's getting pretty serious. A lot of effort is going into it. I'll come on to our fundraising in a bit. One of our judicial review cases relates to that public trust I mentioned, and the All England separately are taking us to court to say there isn't a public trust. It might come on for hearing next year. We're not raising funds for this. We eventually persuaded the All England that they should pay the costs of that fairly interesting case. And finally, we've got the restrictive covenants, which I mentioned when in 1993 the All England promised not to develop, and we've still got that joy to come. That's the view on the right. My Joni Mitchell moment, again, I won't sing it. The view to the right is of Capability Brands layout. It was a golf course. You can see some golf fairways and greens in between the trees. And this is the QR code for our fundraising and links to our website. Those of you with cameras that will read QR codes, most welcome. I'll try to leave that one up so you can see a little more detail from our website. I think that's about it.
Yeah, that's great. Thanks, Chris. There's a couple of minutes if you wanted to ask questions, and you could even put the QR in the chat if you wanted, so people could. But thanks very much. I imagine, do you want to close your, have you finished your slides? Yeah.
I have, I believe.
Do you want
Yes.
to, yeah, that's it. So
I'll stop sharing. Yeah, here we
very
go.
much for that. One question I had, I imagine have you spoken to the White Webs group, who are also on a former?
Oh yes, we've been following it. I cut out the number of links, and this has been developing with a massive team in Wimbledon. And Penny Turndrup is here joining, waving, and we've got a brilliant team in Wimbledon from all disciplines. And we've reached out through CPRE London, who have been massive supporters from the very beginning, and they introduced us to Sean Wilkinson and the White Webs Enfield development. Just standing back from it, that and we are one of the 50 sites under threat around London that CPRE identified as problematic because local authorities had to sell off land. People spotted Greenbelt as ripe for development. And guess what goes first? It's all the trees that go first. White Webs I've been up to the courts with them, and they've been running litigation as well.
Yeah, no, thanks. So, just before we move on, obviously get in touch with Chris. We can share your contacts for anyone.
Yes,
but
please.
any particular sort of pertinent or sort of questions that anyone would like to ask or point out or anything at all? Julia?
Hello, thank you very much, Chris, for your interesting presentation. And I'm sorry to hear that this landscape's under threat, particularly the trees. My question relates to the history of the site. So how much was it changed between it being a capability landscape and being a golf course? And how much of the original capability brown has been retained?
The original estate was between 400 acres and 1,000 acres at its height, because Wimbledon was a tiny little village, and this was a huge suburban estate of the landed gentry of the 18th century. It has a long history. It was encroached and developed during the 19th century and got down to about 200 acres, I think I'm right in saying, which centres on the lake, which was on the middle of the drawing I showed you, a typical capability brown. He dammed up 4 streams to create a lake, a bit like he did at Blenheim and plenty of other sites around the country. And what was significant, we've got old maps and photographs from the 19th century, it was open grazing parkland. Some of it was used for polo, some of it was used for golf, just general public recreation. But the encroachment of suburban development was getting closer and closer, and that's what crystallized the purchase by the Wimbledon Corporation in 1915. I hope that answers your question.
Mainly, thank you.
Penny's just pointing out on the chat, and thank you very much, Penny, that links to our website and crowdfunding and all of that are available in the chat. I think, Penny, is that right?
Yeah. I would say as well as we're an organisation, we're a group that will support other groups as well. Like I've asked for support over the plane tree. So all over the country, we've got different regional groups. So when there is an acute moment in your campaign, reach out to us and we can spread the word and connect you to other. So if you need, loads of people to write emails on one particular day, or if you need an MP writing to, or a politician, so think about that with your own campaigns. If there are particularly acute moments you need support with, do reach out
Well, actually, thank you, Gio. And one thing I might mention for us, we have raised on the crowd justice site, we need to raise about 160,000 for our legals. We're at 120 something thousand. We have 977 donations, separate donations. Last time I looked, there's an average of about £200 a piece generally. A bit less than that on the Crown Justice side. We would love to get it to 1,000 donations. So if you know 23 people who would like to lob in donations, that would be amazing.
I mean, this is where we're battling for our green spaces in the courts. Increasingly, we're taking them to JRs. So, and this is what we're being, you know, I mean, the threat, I was so shocked when I saw that plan, and so shocked when I mean, I'm really shocked. And events, obviously there's a huge issue with events, being our parks being pimped out for events all summer. We have problem in North London. So yeah, Ali, do you want to come in? Yeah.
I just wondered, I presume you've tried the Aarhus Convention to protect you against your costs, because that sounds
Yes,
like
we
a
have.
lot of
Oh
money.
yeah, we've done all that. Thank you. We have our when we applied. Forgive me if you know all this. When you apply for judicial review, you need the leave of the court to bring the case in the first place. And we applied to the court early in January. We were told it would take 2 or 3 months to get approval, and including Aarhus Convention approval. Within 4 days, we were given the lead of Mrs. Justice Lang, who's the senior judge in the administrative division. And she gave us Aarhus Convention, which means if we lose, we pay £10,000. If we win, we can recover £35,000. Of course, that's nothing like the total cost of this sort of litigation, but it protects us against, and I've noticed in the chat someone is mentioning greenwashing, the All England's greenwashing and efforts to say how wonderful it is.
Yeah, thanks so much. Sorry, Ali, what was that thing you mentioned? The something foundation. What was that? Sorry, that you mentioned.
Oh, the convention, the Aarhus cap is.
Could you spell that? Could you put that in the chat?
Yeah, it's AARHUS.
It was a convention, a legal convention that grew out of European environmental law. Based, I think they've signed it in Aarhus in Denmark. That's why it's got that name, and it gives campaigners on environmental topics protection against adverse costs orders, which is really helpful, really necessary, in fact, if you're strapped for cash.
Yeah, I got it for both of my cases. So
yeah,
brilliant.
I saw that Simon from Exmouth Tree Project raised a hand at one point, or
I think he did a fist, like power. But I could be wrong, Simon. Perhaps it was some, yeah, okay, it's power. Power
Thank
to
you.
you.
Sorry.
Power to you.
Thank you.
Okay, this is the way we fight. We're going to have to fight these things on these in the courts. Okay, thank you so much. We've got about sort of, I know Sarah's here. Welcome, Sarah Dodd. She's going to begin at 6:30. We've got about 5 minutes. If someone wants to come in with a slightly quicker update, I don't know, Rob, newbie, and then we can go to other updates after Sarah talks and the Q&A kind of thing. Yeah, Rob.
Right. I'm new to this. It looks, I was invited by a friend, James Murray White, in Cambridge, if anybody knows him. I used to run a coppicing project in a forestry commission, woodland, and I was the last commercial coppicer on forestry commission woodland land. Although we had a contract, they just binned it and said, it doesn't matter, we don't do that anymore. I've envisaged taking them to court, but recent COVID and the rest of it slowed us down somewhat. But James and I, during COVID, set up a project called Save the Oaks, and we planted 285,000 oak trees by various means. We did a bit of crowdfunding exercise, and we got a few trees from an organisation that got hacked during COVID. And so that was another 300,000 trees we arranged to get planted across the country. We, as I say, we did a bit of crowdfunding with that. That was very successful. That sort of still hangs around in the background because we've got a little bit of money in a crowdfunding account. We have set up a link with a group from Holland called More Trees Now, where we go out into woodlands take out trees that aren't going to survive the rigors of nature, and give those away to people, and they can go and plant them where they will, which is fine. I'm in the process of setting up a coppicing liaison group and a CIC liaison group with the backing, hopefully, of the Land Workers Alliance. Unfortunately, I upset for a group called the National Coppice Federation, because I will insist on calling out the Forestry Commission and Forestry England. You can see what they do to woodland behind me. That's a coppice coop. And we were planning to take them to court, Forestry Commission to court, but we were advised that they would just keep running the bill up, so that any money we raised would just disappear. I'm not prepared to let it rest. That's why I'm sitting in and listening to the conversation we're having this evening, which, from what Chris has just said, that's, yeah, I don't think anybody should lie down and take it where they're from. As I say, I will be setting up a group, Five Shires Coppicing, which is around the Rutland area in the East Midlands, and that goes Leicestershire, Nottinghamshire, Nottinghamshire, Lincolnshire, Northamptonshire, where I live, and Cambridgeshire and Rutland. And so we'll be putting a broad arc of groups across that area, and hopefully bringing them all together, so we can all get together and put a bit of pressure on Forestry England. That will do.
Sounds great, Rob. I'm really interested in coppicing and learning more about it. It'd be wonderful to have you talk about it one week, because obviously it's quite a sustainable way of keeping trees alive, and it's always been a big practice in England, and it's dying out, and so it would be really great. Maybe you could come along 1 month and talk about coppicing a bit more, for those of us who only have a superficial understanding of it.
I would love to. I've got a small video. My friend James Murray White, he makes films, and he did a small impromptu video film of me going forth in the woods. I'll send that to you sometime on the link, and then you can have a look at that. But yes, I would be more than happy to sit there and talk about coppicing and trees until everybody wants to, end their own life.
Yes, okay. That's so, and I love digs at the Forestry Commission. So this all sounds wonderful to me. Okay, well, that's great. Let's stay in touch, and I'll speak to Ali and the other team, and we'll try and get you in for a talk about coppicing. Thank you very much. So we'll do lots of other updates after in the latter part of the meeting, because we got too late, of course. But I'm going to welcome now Sarah Dodd from Tree, and now I haven't got your I need to read out your bio. That's what I'm supposed to be doing. Hang on a minute, let me just get it up again, because I had it. Ali, you don't have it to hand, do you? I was supposed to have it in my email.
I'm happy to just talk about myself if you want me.
Yeah, you could talk about, you could do it yourself, but let me just I think, anyway, I'm not going to be able to find it now. But just, perhaps you could just introduce yourself, and because I know you've been an expert in this area for quite a long time, and we're very happy to have you here. I've got your slides. Yeah, do you just want to introduce yourself? Sorry, Sarah.
Yeah, no worries, always. Hi, everybody. I'm Sarah. I'm the founding owner of Tree Law, which is the only UK law firm that specialises in all sorts of claims involving trees. I'm a solicitor. I've been a solicitor for 23 or 24 years now, dealing with tree claims my entire working career. My specialism is subsidence and dealing with trees involving subsidence. So I understand that's what you'd like me to focus on today. But to be honest, I can freestyle. So if there are particular questions that are really interesting that you want to put them in the chat, I'll sort of keep an eye on the chat as well. So I'm happy for this to be as relevant as possible to you guys. So that's me, and that's my business. I'm based in South Wales, which you might be able to hear from my accent. Sometimes I think I've got a bit of a Welsh accent, sometimes I don't. I'm also struggling with a new brace, so if I sound like I can't talk, it's because I can't talk. Yeah, but most of my clients are sort of in London in the southeast, so it is a UK practice, but most of them in sort of your neck of the woods, really.
Great. Okay. So shall I share your slides now, and then you just tell me when you want to move on, kind of thing?
Okay. Am I able to control if you?
Yeah, actually, I mean, I thought you couldn't, but I think you can actually share them as well. So it's whatever you prefer.
Yeah, let me.
Yeah.
Can you guys see that?
Yeah.
Yeah. Okay, fab. As I said, if there's any things that crop up as we're going along, just shout out because I can still see the chat on my screen there. So when Gio asked if I could talk, I was asked to cover off some updated case law, that may be helpful when dealing with tree root subsidence claims. There isn't an enormous amount of case law, and actually the older stuff is still quite relevant. So I thought I would go back and just pick out some of the key cases, probably the ones that I talk about the most, and then talk about two of the most recent cases. Both of them are subsidence. One of them is a civil court case. One of them is a lands tribunal case because it involves a TPO, a TPO protected tree that's been implicated in subsidence damage, which is in a slightly different area of law, but I'll talk about that as well. And these slides are pretty text heavy. I did that on purpose because I think, Gio, are you going to share the slides with everybody? I thought it'd be useful if that I put quite a bit of information on them if you wanted to refer back to them.
Sure. Yeah. Yeah, that's fine. I can do that.
So kicking off with Delaware Mansions, which is like the OG of subsidence case law. It is a House of Lords decision back from 1998. The law that comes from Delaware Mansions still stands. It's just as relevant now as it was back in 1998. It involved a London mansion block, which was being damaged by a plane tree owned by Westminster City Council. The council refused to remove the tree, so underpinning works went ahead to stabilise the property, and then Delaware Mansions insurers sued Westminster to recover the cost of the underpinning work. The law that comes out of this really clarifies the law around nuisance, so the tort of nuisance rather than somebody being a nuisance. And actually, interesting, this goes far further than subsidence cases because Delaware Mansions was referred to recently by the Supreme Court, which is the newer name for the House of Lords, when they were talking about Japanese knotweed. So this sort of encroachment of roots, it's still very much the main piece of case law when you're dealing with that sort of level of encroachment of roots from a tree or something like Japanese knotweed from one person's land to another. So the two key things that came out of this were that if there is encroachment of roots that's causing a nuisance, then that nuisance almost refreshes every day. You might think, well, yeah, what's the purpose of that? What's the purpose of that? Well, the interesting thing about that relates to legal limitation periods. Because if you want to sue somebody to recover money, you've got a 6-year time window to do that. Very roughly, there's lots of nuances to that. But what Delaware Mansions set out is actually that nuisance occurs afresh every day, which almost like keeps that 6-year time clock resetting on a daily basis. So that was a big change there. So it sets out really that if you want to recover the cost of underpinning works, that 6-year time clock is going to start running from the date that the underpinning works finish. Now that's versus what you might have thought previously, which was that the 6-year clock started to run when the crack damage to the property was noticed. And as you guys will be aware, these subsidence cases can go on for years and years. So actually that period of time can quite quickly expire. So that limitation period part of it was a key part from Delaware Mansions. The other key part from Delaware Mansions was that in order to safeguard an ability to sue a local authority to recover those costs, those underpinning costs, you have to have first sent out the local authority what's called a letter to an opportunity to abate letter. So you have to have written to the council to say, you own this tree, we think that tree is causing damage to the property, we want the tree to be removed to stop that damage. If the tree isn't removed, the house will be, or the property will be underpinned, and we will sue you to recover that underpinning cost, and we think it's likely to be around a certain amount of money. Now, unless that letter is sent out, the claimant is unlikely to be able to bring a legal claim against the tree owner. So that's and that letter is often referred to by people as being, you know, local authorities can say, oh, we've received a letter and it's very bullying and intimidating, and there can be quite a bit of pushback about that actual letter. Whereas following Delaware Mansions, that letter is a letter that has to go out, and it's quite formulaic about what that letter has to say. So it's quite prescriptive. So I would say those are sorry, I'm just having a quick look at the chat just in case anything's cropped up. Those are the 2 key points from Delaware Mansions. Now the next one, which caused a little bit of change, is jumping forward to 2012, and that was the case of Berent versus Family Mosaic in London Borough of Islington. You guys might have heard this, but this one changed the law ever so slightly, which had quite a big impact on cases and whether cases can be brought against local authorities to recover damages. What I often hear when I speak to people is that if there's evidence that's showing a tree has caused damage, it can often be perceived that because it's caused the damage, there'll be a claim against the tree owner to recover the cost of that. You know, it's like, well, that's caused it, so it's therefore the tree owner's fault. But that's not correct. That's only one of the steps in the legal test. So in the legal test, you have to show the tree owner owed a duty of care. That duty of care was breached. That breach caused loss, and that loss is within sort of a reasonable range of monetary figures. And what Berent did was it really started to unpick that, whether the tree owner breached their duty, because the tree owner's got a duty to avoid foreseeable loss. And what used to be said was, oh, well, any local authority can foresee that a tree might cause damage, particularly in London, because areas of London are quite prone to subsidence. So that was almost like a tick box exercise. When you're going through the legal test, you know, duty, breach, causation, reasonableness, you just like tick, tick, tick. You definitely tick foreseeability. It wouldn't be an issue. But what Berent did is it started to really put a question mark over that foreseeability, and it started to push things in favour of local authority tree owners, because it said unless there was something that could particularly have put that local authority on notice before the damage occurred that it was a risk, then it would be difficult to find that that local authority could have foreseen the damage, and therefore difficult to find that local authority liable. So we went from a situation where loads of these legal claims would go ahead against local authorities because you just skip past that point in the legal test. But then after Berent in 2012, it got far harder to bring those claims against local authorities, because you would have to gather a lot of evidence to show that the local authority knew that there was a risk. That's when things started happening, like huge Freedom of Information Act requests for the history of other claims in the area. I don't know whether you guys have heard about local authorities doing that. So like a claimant may say, well, the council tree owner should have known that this was an issue because we've got loads of data about past claims, and there was another claim on our street. There were 2 claims on the street, you know, down the road. You know, it's a hotspot area. Because the things that you need to show following Berent to show that a council should have been aware that a tree was a risk was that either that tree had caused problems to that property in the past, which may well have been the case, these things happen more than once, or the property is based in a hotspot area, and you show that hotspot area by showing past claims in the sort of immediate vicinity, or thirdly, that the tree was what's called a real risk. Now, all of these, there's no definition of real risk, so these are all sort of open to interpretation. But my understanding of real risk is that if the tree is so unique in its size, type and location to make it really one of a handful of trees of its sort of category in the borough, such that actually the local authority could be anticipated or expected to put a specific maintenance regime in place in respect to that tree. The tree in Berent, which was classed a real risk, was an enormous tree which was towering above the height of the property and within, you know, a metre or so of the property. So it was incredibly unusual, and that's what sort of created that real risk definition. It's not helpful that none of these have a technical legal definition. And you can go to you could go to a trial arguing that something was in a hotspot area and still be arguing about that before the judge. And actually, one of the cases that I didn't put on this list, which was, I think it was 2016, the case of Petici. Hang on, I'm just going to grab my case law book a second. The case of Petici and Enfield in 2016. They did talk quite a bit about whether an area was a hotspot area, and it was talking about what classifies as past claims to build up that history of claims to be able to create a profile of an area as a hotspot area. And there were quite a few things in there which, so you may like get a map, put loads of pins on there showing past claims, but then after Petici's it said, right, if those past claims relate to a different sort of tree, so say if you're dealing with the plane tree, if any of those past claims aren't plane tree claims, eliminate them. So turn off those pins, you turn them off. And then you think, if any of those past claims didn't result in the council paying out a damages award, eliminate them. So then you turn all them off. And then it's, if any of those past claims involving the same tree and a damages payment, the damages payment was less than £5,000, turn that pin off. Well, you can imagine you could have gone from a map full of pins, profiling this area as a real hotspot area for claims, but put those filters on, and you're going to be filtering down to 1 or 2 pins at best. So then after the Petici case, I was thinking, it's almost going to be impossible to show, if we're applying filters like that, that any area would be a hotspot area. So that just shows, you know, I'm saying that not to give you anything definite, but just to show that it can be really difficult to prove that an area is classed as a hotspot area for subsidence cases. Let me just have a quick look at the chat. So this is the most recent case law, civil case decision on subsidence. So it's the Mpanga and Ealing case that was from 2021. I think so. This is giving you a flavour of the fact that not very many of these go to trial. You know, I've got one in 1998, one in 2012, and I spoke about Petici's in 2016 and this in 2021. Like, there just really isn't many of these, and this is what can be quite frustrating, in that a lot of these cases are dealt with outside of the court. So the parties will reach a settlement between themselves or reach a settlement at mediation, which, you know, as a lawyer, that's great settling for your clients because it brings things to a close quicker, it's all less stressful, etc. All the positives of mediation. But the downside of that is mediation doesn't leave a trail, it doesn't set a precedent, it's confidential, so you don't ever find out what happens at it. And as a result, it's difficult to track whether there is a change in judicial mindset as to how these cases will be dealt with, because there isn't that huge catalogue of judicial decisions. I feel that I need to temper myself sometimes, because I feel that I feel quite positive that if a case were to go to a civil court, a county court or a high court judge, in relation to subsidence, that the environment would be quite high up on the agenda there. But I'm worried that I've created an echo chamber for myself, and I'm feeling too positive about whether that would happen. So I don't know. I'm not giving anything, and I can't give an idea about whether that would happen. But anyway, the Impanga case, 2021. So claimant claimed that a tree owned by Ealing caused subsidence damage to their property. This is an unusual one in that insurers aren't involved in this, so no insurance company involved in this. We can't be angry at insurers on this one. So Impanga was claiming for what they said was a diminution in value of their property. They said that the property had suffered damage as a result of Ealing's tree, and it affected the value of the property, lowering the value by £100,000. The case didn't actually end up going ahead because it was dismissed on the grounds of limitations. The limitation is that 6-year clock I was talking about earlier. That actually the damage there started in 2011. And they didn't start off their legal claim until 2017. So by the looks of things, they probably missed it by a couple of months. So it ended up failing basically it had been done too late. But even though it sort of fell at the first hurdle, if you like, and it failed immediately on limitation, the court did set out what they would have said in relation to the substantive parts of it to at least give some help, so it wasn't just sort of a failure on being out of time. So the court said that the tree was considered small, well-managed and appropriate for its location. So it doesn't sound like this is a real risk tree in any way, shape or form. It was regularly pruned and inspected, just giving me the impression that Ealing are acting quite reasonably in maintaining it. So the claimants failed to show it was a real risk. Yeah, no real sign of that. Historical evidence in the area did not amount to the area being a hotspot area for claims, or obviously limited number of pins on the map in relation to past claims. And actually, had there been a diminution in value of the property, it would have been no more than £4,000. So this seems to be one where actually the claimant perceived that they had suffered a greater loss than they actually had. If I was pursuing a claim like this and wanting to bring a claim for diminution in value, I wouldn't do that, or I'd certainly advise the client not to do that without significant expert valuation evidence. You'd ordinarily get 2 or 3 valuation reports to set out whether actually the value of the property had been affected. Probably sounds like they didn't really do that, because that's quite a difference between 4,000 and 100,000. And then finally, this is the most up-to-date, so 2025, and you guys may have heard this one, and this one's moved a subsidence case, but it's not one that was in the civil court as such, it was one that went to the Lands Tribunal. And this case went to the Lands Tribunal because the tree that was alleged to have been causing damage to the property was protected by a TPO. Now, this is the combo that seems to get the most attention, I would say. Tree causing damage, or alleged to be causing damage to a property, trees protected by a TPO, and you've got 3 parties in the mix. You've got the homeowner and insurance company, and then you've got the planning authority. There's a big drive for change in how planning authorities deal with these applications for tree preservation orders to be removed, because across the UK, there's a feeling of reluctance for planning authorities to reject these applications, because there can be concern that they're going to face quite a large legal claim if they reject them. Because if the planning authority gets an application to remove a TPO tree because it's implicated in subsidence and they refuse it, then even if they're not tree owners, they're just the planning authority managing the protection on the tree, they immediately then open themselves up to a possible claim for compensation from the insurer that's carrying out the work to stabilise the property. That's a big area of debate. Planning authorities in those situations have no insurance cover for that potential legal liability, which makes them feel incredibly nervous. It's not like the sort of insurance cover they would get if they were the owner of their own street tree. Obviously, the municipal insurance would cover them for that, but they have no insurance cover for these cases. which makes it an area where it's prone for them to feel that they have to consent to the felling, because if they don't, they're facing too much of a financial risk. So in Chubb, the last one of these Lands Tribunal TPO cases, actually it was an interesting one, this was, because if you're going to pursue a claim for compensation from a local authority, you would have thought that all of your causation evidence, so that step which shows that the tree is actually causing the damage, would have been absolutely bulletproof. You'd think you had that absolutely nailed down, because you wouldn't want to go into the fight on the other things unless that was sure. But actually, the outcome of that was that the causation evidence, the evidence linking the tree to the damage, wasn't strong enough. So actually it almost like fell at the first hurdle, that the court found that the claimant had failed to show on the balance of probabilities that the tree involved in it was actually a cause of the subsidence. And do you know what? Observing this and speaking to planning authorities and people that are concerned when significant oaks, you know, old trees, precious trees are in the firing line of subsidence claims, I see this a lot, so the evidence is quite weak. And that the request for felling is robust, but actually the evidence behind it is weak. So that's exactly what happened here, really. It was rubbish evidence, and the claim failed on that basis. I'm conscious that I've probably just gone over my 20 minutes, Joe. So I'll stop talking now.
Thanks so much, Sarah. Do you want to just close down your slides? And thanks very much for those. It's very useful. Yeah, we found you dig into these cases, you often find that the evidence is quite weak and contradictory and outdated as well. And obviously we have our Oakfield plane tree. Can I ask you a specific question? Can I jump in selfishly?
Yeah.
For my own campaign, you know, obviously the plane tree, the threat to the plane tree is back. Both insurers, under enormous pressure after many, many years, have finally agreed to settle with the homeowners. So I'm not going to get too much into that. They've agreed to settle. So the homeowners now both houses plan to underpin later this year. So this case has been rumbling on for a long time. But once the houses are underpinned, but the council still, Haringey Council still intend to fell the tree. Just wondering
why?
Right. So we feel there's a lot more going on behind the scenes, these two insurers, Allianz and Aviva, but what they're saying is, they're stating publicly is, pollarding hasn't worked, other alternatives have been looked into, which we find very weak, like such as root barriers. They're just not, it's not a credible solution, but I don't think they've meaningfully tried any other solutions particularly. They haven't done independent monitoring, so there's no independent reports. They're also saying they're going on the JR from last year, but that refers to, you know, a decision they made 2 years ago. So we're saying the landscape's changed, the whole situation's changed now. So why it's not rational now to decide to fell? There's new evidence, you know, as in there's new information. We know the houses are going to be underpinned. Why do you think a council, just on I mean, maybe it would be a hunch or a kind of hypothesis, but why do you think our council would still be pursuing the felling of the tree when the houses are going to be underpinned?
I don't know. I have seen this sort of thing happen in the past where the sort of juggernaut of the whole council system has reached over a long period of time a decision to do something. It's gone to a committee, it's been approved. That's a decision that they've made, and they almost, and this may not be what's happened here, but they almost stick to that regardless of whether anything changes, and then they push on and on and on and on with it, because they don't want to backtrack. I'm absolutely not. I don't know whether that's happened here. Do you think
the insurers behind the scenes might be still pursuing costs? Could they still be, because they've agreed to settle with the homeowners, but they'd still be trying to get the council to pay to recoup some of their costs? Do you think that might be? I mean, it's all hypothesis, isn't it?
So say if Aviva and Allianz have paid, you know, so they've paid 100 grand each to their insurers, it'd be more than that to underpin their house. Then Allianz and Aviva will each have a claim to recover that cost from the council. Whether the council fell the tree now or not, that makes no difference to whether Allianz and Aviva have got a claim to recover those underpinning costs.
Yeah.
Yeah.
It's puzzling to us. Right, other questions from people who had anyone have a particular question? I suppose we're interested in how is it going to help us as tree campaigners? What do you know that might help us? Kit, do you want to come in here?
Yeah, so we've got a specific question from Friends of St Matthew's piece in Cambridge, but I think it is something that applies to a lot of these kinds of things. I've put you a little essay in the chat detailing it. Essentially, in our case, the claim of subsidence seems questionable to us as lay people. I can go into more detail about that, but we're fairly confident the actual claim of damage to the house has not been evidenced. What they have presented is some levels monitoring data, which we feel is quite contradictory. We're a bit unsure about the reference point they use for that. For example, it does show the ground going down in the winter, which is not what you would expect from. Yeah. What we need is somebody, ideally a structural engineer, to look through this data. We have some very specific questions about it, and we need someone to offer an opinion that we can then offer in planning committee to explain. We don't even think underpinning would be warranted because there's no evidence of damage from our point of view.
Yeah.
We've shopped around and we've not really, we can fundraise and we can pay for the opinion, but we've not managed to find anybody who's willing to offer that. I just wondered if you had any advice about how to put together something to present to planning committees when you are going through the data surrounding a subsidence claim, who to contact, who might be able to help groups like us.
No is a short answer. Like in the past, I remember I did a report for a campaigning group client on a subsidence case that then got read out in a planning committee meeting. It's difficult. It was read out in a planning committee meeting, but nobody really. That was what I was saying to Gia. When people, I often feel that the committee's so committed to the decision that they've made, they'll just sort of ignore things that are being raised and just keep going down the path that they were committed to.
Just a bit more context with this one. This application to fill these trees has come up 4 times now and has been denied each time. This latest application, the only extra information given is that now they say not only do they want to underpin the house, they've moved on to say it requires a raft foundation and more expensive works on it, basically to frighten the council, I think. So the council is inclined to decline it, but the fact that this keeps going, we'd like to be able to shut it down because it's wasting everyone's time at this point. And if we can actually get someone to say on record, you haven't shown any evidence that these works would ever be necessary, that would stop us being back here in 6 months' time. It has been relentless.
Yeah, I mean, I could recommend some engineers, but I can tell you that it may not all go to plan. And the reason I say that is in the one that I was talking about, I did a report setting out all the reasons why I didn't think the causation evidence stacked up, and therefore why the planning authority didn't face a real risk of a legal claim. The committee agreed that they would pause the felling of the tree, because they'd agreed to fell it. They'd pause it and they'd get their own structural engineers reports that could tell them whether they did actually face a risk. And I thought, this is great news. They went away and got a report. They came back after the pause and they said, we've got a report, it's confirmed what we thought, so we're going to go ahead and fell. And then fast forward a few months later, and I was on a Teams call with someone, and he said, oh, what happened to that case? Because I was asked to do a report for that. I was the engineer that did a report. And he said, and I just totally agreed with everything that you'd said in your report and said, no problem here, don't fell. And I said, well, we were told that your report said the opposite, and they carried on and fouled. So
yeah, that's really shocking. Janny,
yeah,
I'm going to bring Janny in, sorry.
Yeah, I just wanted to add that in fact the structural engineer's report of the insurer said that there was minimal damage.
Mm.
And it has never...
And it said that the damage was not only minimal, but not characteristic of subsidence.
Of subsidence, you know.
Their own
So
report.
this isn't their own, you know. We're also, the trees also have TPOs, and, you know, and they're also in a conservation area, so they're doubly protected. They have been, and we've been fighting to protect these trees now for, you know, 5 years, basically. Well, even longer. So the thing is that we, you know, we would like to get our own structural engineers report just to give, but it's not like we're fighting the council. I feel like we're fighting a vexatious insurance company, and we know that insurance companies are a big problem in this area. You know.
They are, and you know, these sorts of situations with insurance companies do get a lot of attention. What insurers are doing, they're totally, you know, the law is there to allow them to do exactly what they're doing. These are the legal steps that they can take. So there's no, you know, nothing's being done that shouldn't be done in law. But I think the difficulty is, and this is a bit that I get frustrated with, is I think there's not an equality of understanding between both sides. So the insurers perhaps might send patchy evidence or not great evidence or evidence with gaps or incomplete or not very strong. But actually the planning authority that's receiving that and trying to review it and decide, are they going to consent or not, when they could potentially be facing a significantly sized legal claim. There's that mismatch of understanding.
I would say though that the home insurance industry companies they've established the case or tort law. They've established the precedent. So they have, you know, that's been established by them over decades. So when you say they're following the law, this is a law they've shaped and established. Yeah.
They haven't made the law, so
they've taken cases to court, so it's like tort or civil. They've established cases which become the precedent, which then is referred to.
Yeah, but it's slightly different in the Lands Tribunal in that the legal ability to bring a claim against the planning authority for refusing an application for a TPO is set out in statute.
Yeah, I know certain bits of the law are, but my understanding was that I'm always being told that we need new case law. We need new cases that are going to challenge these established cases that are used, and you know, this is why people are afraid to take, you know, councils are afraid to go to court, residents are afraid to go to court against insurance companies because they've got so much money, they've got the law behind them, the case law, the history that they can refer to, you know, that will, you know, the weight of it is kind of rigged against anyone who's trying to challenge the felling of trees, you know, the pressures.
I would say since 2012 in the Barrett case, things have swung significantly in favour of local authorities, and actually it's very difficult to have a successful claim in damages against a local authority in the civil court. So that's not a TPO case, that's a street tree case. Right. The TPO cases, they're hard anyway. Look, like that's my book of case law involving the civil courts. You can see there's loads of court decisions. That's my case law involving TPOs.
Yeah.
There's just not much case law. It's a little bit, people going inside quite blind, not really knowing what might happen.
But not all street trees, most street trees aren't TPO'd, are they? That's the issue. So if, you know,
most trees in most TPO trees are being private ownership.
Yeah. I'm just going to bring in a couple. Simon, who's been waiting patiently for the Expert Tree Project, and then Paul. Simon, do you want to come in?
Oh, hi. Thanks everyone for what you're doing. And thanks, Sarah, for the reply earlier, a brief reply. Yeah, we've got a very similar case by the sounds of it in Exmouth again. We had one last year, and the owner buckled and the local authority buckled and the oak was gone. But this one looks a bit more favourable. The evidence looks a bit dodgy. There was all sorts of things happening with them not being notified. All their neighbours were notified, but the owners weren't. So they're trying to delay it. I'm just wondering, it's obviously too much to go into detail now, but as far as the owners getting some advice, is that something that they could book a consultation call with you, Sarah?
Yeah, they could. I've been in touch with somebody from the planning authority who'd raised that as an issue with the Trees and Design Action Group, and I got copied into that. And he said, because I said, I'll give you a free hour where I can talk you through the evidence and tell you actually whether I think you do genuinely face a risk. His response was, I think that hour would be better spent if you spoke to the property owner.
Right, okay.
So yeah, I'll be more than happy to. If you want to pass my details on to them and encourage them to get in touch, I'm happy to speak to them about that.
Thank you. That's really good. Thanks a lot.
Thanks very much. I'm just going to bring in Paul Powsland here, and then I'll go to Kit.
Yeah, I think it's really interesting, your conclusions about the case law often supporting the retention of the tree. I think a lot of the case, the difficulty is that it's a three-way dispute. It's not just the people who want the tree versus the people who want to save the tree. It's the people who want the tree gone, the insurers, and the homeowner. So four-way, and the homeowner, and the local authority, and then maybe local protesters who want to keep the tree. So it often feels like we're sort of fighting with our hands behind our back, because the local authority ultimately may not care that much about the tree and they just want to avoid the cost. So even if they did have a good case, it's basically in their interest a lot of the time to just fell the tree, because, you know, why bother spending all that time and effort and money to fight for something, even if you're going to win, if you're not that bothered by keeping the tree in the first place. And then they often don't release the reports and things that are necessary to fight the case to the local protesters, citing confidentiality in legal disputes. And so it's the stage removed from the actual fight that I think is a lot of the difficulties in these cases. I don't know if there's a solution to that, but it'd be interesting to hear your thoughts on it.
I think that. So are you thinking there, Paul, about a TPO-based case or a case where the council is tree owner?
Usually tree owner. I don't come across that many TPO cases. It's usually the highway tree, council owns it, and it's implicated in some form of damage. And yeah.
My experience of that is almost like the reverse, and I'm seeing local authorities really pushing back on them and saying no, that they won't fell without significant causation evidence. You're not doing the reverse, are you? That
maybe it's the difference in the kind of cases we get, because you're getting cases where you're sort of fighting it out, whereas we're getting the cases where local tree protectors are trying to stop a tree being felled, which is going to naturally be the cases where the council is trying to or not caring as much. But in those cases, I've just found it really difficult, because I'm like, well, I'd love to give an opinion about causation, but I can't without any report. And in a lot of cases, the council just won't release the reports to local people. So
because if it was a TPO, and I'm sorry we're bouncing from TPO to non-TPO, you'd see the you'd see the site investigation evidence on the portal, wouldn't you? So you'd see everything you needed in the TPO case would be publicly on the portal. In the other cases, you're not seeing it. So when they're doing like a duty to consult, you're not getting access to any of that causative.
No. So they're not, like, our council is not consulting transparently. They're not giving the public all the evidence. They're not giving the public a great amount of detail. So in a way you could argue it's not a proper consultation, because it's not really laying out all the facts on the table.
And the King George Oak, they were like, the council refused to release the reports, so the tree protectors had to raise like £5,000 to go and get their own reports, and even then the council won't really say. Down in Falmouth, they literally won't tell them why we think it's subsidence, but they won't even reveal what the reason is, because they said it's confidential. It's like, well, how do you even begin to fight that, because you don't know what the hell you're fighting? So it's quite difficult.
I'm just going to bring in Kit, who was waiting, and then Janny again. Sorry.
Yeah, so in our case, we're dealing with TPO, so we do have the documents. I'm just wondering, and it's coming back to a question someone else asked in the chat, what would you usually find as sufficient evidence that there is damage to a property from subsidence? What would be the normal kind of presented evidence?
what you'd usually get, and if you look to the Institute of Structural Engineers handbooks, this is what it says all insurers do, which they don't, but this is what it says they do. Step 1 should be drain survey. Eliminate a leaking drain as the cause of the damage, first of all.
Right. This is the Institute of Structural Engineers handbook.
Yes.
Okay.
Which you can buy. It's relatively inexpensive, like 75 or 80 pounds. That's inexpensive.
I mean, relatively inexpensive, depending.
That's inexpensive, like a textbook. Sorry, that sounded so, sorry.
Yeah. No, carry on.
Step 1, drains, and then once you've eliminated, if it's fine that there's leaking drains, then fix the drains and then see, has that solved the problem. So step 2, then you generally expect to see soil tests. So that's trial pits and boreholes, identifying the soil type. Is it dry?
Did you say 12? What did you say? Drill.
Trial pits or boreholes.
Trial pits.
Sorry.
Trial pits, yeah. Identifying whether the soil is, what sort of soil it is, whether it's dry, how deep the foundations are is usually done as part of that test as well, because you'll dig the borehole next to the foundation, the edge of the property. You can do various soil tests like liquid limits, suction tests, plasticity tests. There's lots of different ways really just to show how does the soil behave when there's moisture in it or moisture taken out of it. Then you'll remove roots from the soil. Have roots been removed? Are they found underneath the foundations? And have they been identified as coming from the tree that is implicated? And are they alive? Lots of times you see dead roots, which is always a bit of a question mark. And then monitoring. Monitoring is a key one, whether that's crack monitoring or level monitoring, and you really want to see that pattern of movement over the seasons. So you were saying earlier, Kit, that it seems to be going in the wrong direction. So you want to be seeing that downward movement in the summer as the soil shrinks, and then back up in the winter, down, up. And then also another thing, a bit more anecdotal, I suppose, is where the cracks have appeared in the property. You can often see comment about certain trees being implicated because of the way in which the property is sort of rotating and cracking and leaning towards a particular tree. So maybe some like anecdotal comment about the location of the cracks. But I would say that's probably.
Would you expect any of these investigations to be done if there were no cracks at any stage indicative of subsidence?
I don't think you can really tell whether the cracks are indicative of subsidence until you've done some tests.
Okay. So if there were some hairline cracks in the property, that would justify going on to do these investigations.
Like, insurers don't accept subsidence claims, willy-nilly. And I see a lot of cases where insurance companies have refused to cover a claim because they're saying that damage is either sort of too minor or it's not subsidence. They'll reject the claim. So the fact that if there was an insurance company involved, they've accepted the claim, they've accepted its subsidence, suggests to me an engineer of some sort, has been out and concluded that it looks like there is a.
That's the weird thing. Their original report said explicitly, like, there's some mild cracking, it's not indicative of subsidence. And then for some reason they went on to levels monitoring, and we're missing that kind of information as to why they did that.
I wonder if maybe you could contact, like, maybe because I'm just sort of aware of time. We've only got like about 3/4 left for other updates. But sorry, I didn't mean to sort of cut it all.
I was going to say, Kit, if you've got all of those things electronically, ping them over to me because it won't take me long to look at them. Ping them over to me, and I'll give you some ideas.
Yeah,
I would love to. Is your email address?
Oh, should I pop it in the chat?
Yes, please.
I mean, I think we've got to remember also that a tree only has to be implicated in damage to be felled. That can force its felling. And that, I think, is one of the central problems for us. There's a range of other factors. In Haringey, we're on this very dense clay soil, poor foundations of Victorian houses. We've got loads and loads of claims in Haringey.
The house was built in the 1990s.
Yeah. So I think we've got to learn. I mean, the industry has to change. We've got to learn houses should not be pitted, trees should not be pitted against houses. People need to, live a bit more with cracks in their houses. We've got to think about the climate emergency. We can't just fell all the trees. If you follow the line of reasoning, you'll end up felling all the trees in Haringey and beyond. I mean, you know, if you follow that logic of risk and future risk, you know, so I think the problem is blaming a tree for most of the damage when actually it only has to be implicated. That's a fundamental issue with this.
It only has to be implicated potentially for felling, but in terms of a legal claim, it's got to have been a primary cause of the damage for a legal claim to follow.
It has direct primary cause of damage.
Can I just say one final thing about this, which is that this house, which is a very poorly constructed modern house, was built on top of the trees that were already 100 years old. These trees were planted in 1898 and given to the community for their enjoyment.
Thank you for that. I'm sorry to, I mean, I understand that as far as we understood, it just had to be implicated in damage to force a council to kind of fell it. I didn't know.
There are two different stages of a claim you're talking about there. So the stage where you're talking about a tree being implicated in the damage as being a reason for it to be felled, that's in the sort of mitigation stage of the claim. I'm talking about the stage of the claim where it goes on to become a legal recovery of damages. At that point, the tree needs to be a primary cause in order to be able to make that legal recovery of damages.
Okay, that's good to know. I didn't understand. Sorry. And Valerie, you had your hand up, and now, are you sure? Yeah. Okay. Would anyone else, just a sort of final question, Ali, before we let Sarah go after? Yeah.
Yeah, thank you, Sarah. It's a very non-subsidency question, which is unusual. How is there a limit for how long a council has to respond to a TPO request?
Yeah, they should respond in 8 weeks.
But is that like the law or a rule, or have they got discretion on that?
They have to validate so a TPO application has got to have certain levels of evidence attached to it. Once it arrives with the council then validate it to say, okay, it's arrived, it's got everything that we need, we can now start our review. So from the date of validation, they've got 8 weeks to come back with a response. If they don't come back with a response, I think you can deem that to be a refusal. I can't tell you off the top of my head where that 8 week period is set out. It will be somewhere in the tree preservation regulations, I expect.
Right.
So 13 months would definitely be too long in that case.
Yes.
We finally got a TPO on an oak tree around the corner, which was fantastic. It only took 3 years. So
well done. Well, in this case, they haven't. I don't think they could reasonably say they've refused it, because we've seen emails where the tree officer's saying, you know, it warrants one, but I'm not basically, they're just refusing to determine it.
Oh, what question are you asking, Ali? Because I was answering the question like, how long has the council got to respond to an application to remove a TPO?
Oh no, sorry, a request to put a TPO on a tree.
Oh, right, okay, yeah, scrap that then. That 8 week is irrelevant.
Okay, so and just to clarify, so that's very interesting. I didn't realise. So just going back, if the insurers are chasing the council for costs, as a hypothesis in our case, does that mean that that's a legal recovery? That's in that bit where they'd have to prove that it was a direct cause and the only cause of subsidence to the council to recover those costs. Is that what you're saying?
It's slightly different. So the one that I was talking about was a claim in nuisance and negligence. The one TPOs, that's more of a statute-based claim. There's still the causation element in it, but it's slightly different. Probably not too different, but I wouldn't apply that same rule across both of them necessarily.
Right. This is not a TPO tree, but anyway, it's slightly complex. Maybe I'll get in touch with you and try and clarify it, because it's good to know. Thank you so much, Sarah. It's really great to have those cases outlined so clearly on those slides. They're incredibly useful for us to refer to. And yeah, I really appreciate you coming along. So thanks very much.
Thank you.
Okay, no problem.
I'll see you. I would speak to you and see you in the morning.
See you in the morning. I'll be prepping.
Good luck in the morning.
Okay, bye. Thanks a lot. Okay, great. Okay, so we're going back to sort of updates. So so the people that we did not get to was we didn't get to Sally from Chidswell, is that right? Is Sally here?
I didn't see her come in.
Oh,
So
okay. Well, not to worry. Who else is new and would like to update or just tell us about your tree campaign or anything at all, really? I know a few people put their hands up and I can't. Ah, Gordon, yes. Do you want to come in and introduce yourself and or give us an update? I think you've been before. Yeah.
No problem. Yeah, no, it's fascinating listening to Sarah and all the chat that's gone on so far. We're slightly different. We're a private family with our own 150-year oak tree in our garden that is causing subsidence here behind me, been going on for 5 years, and we're refusing to have our own tree cut down. And the insurance company is challenging us and making it very hard for us to continue. Up until 2 days ago, we didn't have any insurance. They cancelled our insurance because we've been refusing to follow their suggestions, even though we have 2 independent engineers report saying that it's not just the tree that's implicated. And this is what Sarah and yourselves were leading to. There's other things going on. It's very high plasticity clay. It's very shallow foundations of a 1950s building. And we've been getting details from the Met Office that the weather during the May of 2020 was incredibly dry, incredibly hot, and therefore the water levels and the desiccation, as they call it, from the tree was really struggling. So we're still fighting that, and yeah, we're at our ends now. We don't really know what to do anymore. Possibly we've got to go to the Ombudsman. I think we've got about 6 months before we run out of this 6-year thing, so I might contact Sarah and see what she was saying about that. But that's where we're at. We've got our own tree. We don't want to chop it down. We think it's not solely to blame. It's to do with the foundations, the very high plasticity clay, and the climate change that we're all witnessing. And the insurance company is trying to stop us. Yeah, go for it.
Can I ask who the insurer is?
Yeah, it's Direct Line, and they're from Aviva, and they use a loss adjuster called 360, and it seems to be their standard practice to just frame the whole argument on the tree. So we're trying to draw up a set of reports to frame the argument back to the foundations, because this tree started in 1865. The house was built in 1950. Foundations went down first. The tree's been there for a long time.
Yeah, it's shocking, absolutely shocking. Is there a TPO on the tree?
No, we don't need it. It's our tree. We've had the insurance companies. We've had the insurance company stand in our kitchen, telling us that if we put a TPO on it, they would just sue the council for any work that's done. And that sounds to be the case that's happening with you guys around that. Councils put TPOs on, the insurance companies sue them, they can't afford it, so they remove the TPO. And the insurance companies want the councils to have TPO so they can go after them to claim the funds back. We're the individuals, so we're liable. We've had independent valuations from 3 different estate agents, and the value of the house has gone down by £250,000. So we're already out of pocket.
Really sad. I mean, it's more than sad, it's tragic. Lawrence, do you want to come in? Oh, you're still muted.
Hi. Sorry, I didn't mean to put my hand up to that case, just to give an update.
Oh, okay. Well, I'll bring you in in a sec. Sorry, I just wanted to. Did anyone have anything useful or sorry to say to Gordon? I mean, I see my understanding has always been that insurers have established enough case law to make a precedent that they can implicate a tree in damage and it can be felled. So all they have to prove is sometimes really scant evidence, to pressure people to fell a tree. That was my understanding. I don't quite know. I didn't quite understand the complexities of the different bits of law, but this is a really shocking case. Have you been in touch with the Woodland Trust at all? Because this is an oak tree. It's a valuable tree. You said it's about 150 years old. I mean,
So they've measured it and we've measured it. The insurance company, it's 310 centimeters circumference, which gives it over a meter in diameter. So that places it about 150, 160 years. But we're in a leafy area in a rural setting. There's trees like this all around.
Yeah.
So your caveat and amenity value, they just get ignored. But actually, the whole country at the moment, we must plant loads of trees, but then they cut down a veteran tree. The situation doesn't make sense.
I mean, of course, it's irrational because we could fell all our trees because they might cause damage to houses. I mean, it's irrational because you can't fell trees for potential future. And also the arguments, obviously, we've been in a drought, a very bad drought this year as well, although it's raining today. So, I mean, the pressures on trees, there was a spike a few years ago, 400% claims, the amount of claims went up, and it's a shocking situation that needs adjusting or amending in the law. We need to get more case law on the books. I don't quite know how we do it, either an amendment to the existing law or just different cases that actually challenge the way trees can just be felled. There's got to be a way of trees and houses to live together. I mean, and it's these commercial companies, these profit-driven companies that are just wriggling out of, they don't want to spend, they don't want to pay their dues to homeowners. And your subsidence may continue. The tree may be felled, and of course you're still on the clay soil, you still have poor foundations, and they don't do the foundation work. So
yeah, both our independent structural engineers reports have said that any felling of the tree would just be a temporary solution. Because we're on very high plasticity clay and shallow foundations, the house will continue to move into the future, and possibly felling the tree, the heave will be so great that the house will bounce back up and go past where it was. So yeah, we're just hitting our head against a brick wall.
Yeah. Heave is a big issue. Does anyone have any? I know someone whose house isn't insured around here, and they've just thought, screw it, I'm not gonna. Does anyone have any further suggestions for Gordon about what any other routes, apart from he has this evidence, maybe taking it to?
Or if anyone knows a way to formulate writing to the Ombudsman, because that's where we're at now. I'm writing the report myself, including our engineers' reports and counting the insurance report. But I've never written to the Ombudsman before. I have no idea what I'm supposed to do. So if anyone out there has any suggestions.
Could I make a quick point?
Yeah.
That perhaps if the tree is significantly valued in the local community, you could approach the Ancient Tree Forum, and you could apply for veteran status, which we have with our campaign, which I'll hopefully be able to touch on later. But basically, you're saying that this tree is in the public domain, or it's of significant interest, and therefore it has a higher value, higher amenity value, or number of other causes. And obviously, get a caveat. We know that a local authority or an insurer will massively undervalue a tree, and possibly not even value it correctly. They'll value it on the cost of removal. To remove the tree is £5,000. Actually, the caveat value is 75 grand. So putting all these cases together, my shift liability towards the cost of replacement of the tree as opposed to its removal, which I think local authorities and insurers are sort of unaware of. They go for the cheapest option.
Yeah, thank you. I'm just going to bring in Kit.
Yeah, just related to that, is there any way that we could hold, or someone could hold insurers responsible for compensating for the loss of that monetary value? I mean, caveat is one way to assess it, and I know that councils do that. Surely somebody ought to be reimbursing. It shouldn't just be a toss-up between the council potentially being liable for underpinning and the cost of removing the tree. That caveat value should be reclaimed from somewhere, maybe. Surely there's some way to get insurance.
It's an ability to hold people accountable.
Yeah.
So in our circumstance, we have valued a tree at 75k on a caveat value.
Yeah.
And I've proposed to the Ancient Tree Forum that it is a tree capable of a veteran status, and therefore, because it's been in numerous different levels of media, print media predominantly, there's a higher value to it. So I'm going to value that tree at £300,000. I'm going to value it at £500,000 or 25 grand.
if insurers knew that they might be held liable for that valuation, they might have to pay the community that money to compensate them for the loss of the tree.
Quite right, and
Maybe
could
that
start-
would deter them from going straight to tree removal.
Quite
yeah.
right. That could start with valuing the tree correctly. Yes, Kappa is obviously a fantastic method and everything like that. But if you say, actually, that tree is worth 75 grand, let's use that as a datum point.
Yeah.
I want to be reimbursed £75,000 for taking the tree out. Well, all of a sudden, the insurers less likely
they're going to be less thrilled at
develop.
the idea of removing the tree, right? So yeah, I think Ali said she was going to ask.
That's great. Can I ask, Lawrence, how old is Chester, your plane tree?
My Chester is about 150 years old.
Right, okay. Because ours has been, how much was ours calculated at, Joe? It's 120 years old, our tree.
So, well, Haringey Council did a caveat of 65,000.
Yeah.
How accurate that is, we don't know.
Yeah. That's interesting. And that was 3 years ago, wasn't it? Okay. Right.
Can Gordon see that Val has put in the whole procedure for working on the caveat?
Yeah.
Working out? Yeah.
I've seen that, and that's great. We're in a rural setting. There's loads. We're in a fortunate position. There's loads of veteran oak trees all around here. So it's in our garden. So trying to get the community to stand for one tree, they don't understand the process. And also, so everyone is aware of Aviva Insurance and Direct Line Insurance in their policy and procedure documents, they value any tree at £1,000. So they've already covered the litigation of removal of a tree to a maximum value of £1,000.
The thing is, it's so interesting, isn't it? It's just one tree. We hear that a lot. It's just one tree, but cumulatively, one tree becomes another tree, becomes another tree, and we're deforesting the world. You know, we're deforesting our streets and our world. So it's, I mean, that's just BS. I you know, and the thing is, it's a really important tree to you. I wonder whether you have sort of closer people that, do you have a little group around you that are supporting you, or is it just your family pitted against the car insurers, do you feel?
It's just me and my wife against the insurance company, almost, over 5 years now. And we're just getting to
very,
the
very
stage.
stressful. And they use very bullying language. I'm really sorry to hear about your case. If there's any way we can help support again, do just send an email out to ask if there's any, like the ombudsman or anything at all. I don't know what the rules are with ombudsman. I don't know whether you have to live in the vicinity in the area or whether, so I'm really sorry. I just, obviously we would hope that you would, you know, I just wonder whether there's a legal, are you going to a legal, would you be able to go to crowdfund for a legal case or?
Well, I think I'll speak to Sarah after seeing her and listening to what she said. I'll make that first contact with her and then see where we go from there.
And obviously the value of is incredible.
The ombudsman isn't holding anyway. I mean, if it finds in favour, then the insurance company will have to go with the ombudsman. But if it's not in favour, we can then take legal proceedings if we need to.
Yeah. So the financial ombudsman in the cases of the homeowners near us, it basically said work on the house, and it didn't even mention the tree. Do the work on the house, and that's what they've been wriggling out of ever since. Except they came to the pressure we exerted and the homeowners exerted. They settled this year because it became a big, high-profile case.
Can I interject very slightly, ever so quickly?
Yes.
You should view yourself as a sort of perhaps an urban ecologist, and you know, if we can combine the world of arbor or trees or whatever with the ecology, then I think we have a lot more legal standing and everything like that. I know, you know, I know loads of people put bat boxes in, bird boxes in, and everything like that. But if there's a way that you could tie together a number of sort of factors, that also makes the insurance take note. So just something to perhaps sort of think about as well.
Okay, thanks for that. Right, some more updates. Who's new to the group? I will bring you in, Lawrence. I know you want to update about Chester, But can I ask who is new and who would like to do an update, or an update and as well as being new? Julia.
Thanks, Gio. So I'm really new to the group, and Gio, thank you for inviting me after meeting me very briefly last week. I'll keep this brief. I'm a photographer and a researcher. So my research is very much around landscape, environment, political ecologies, and so on. And I'm interested in starting a research project around community action and trees, but it's likely to be something that is very visually orientated. I'll make contact with the Save Wimbledon Park group, because one of the things I might be able to offer are some kind of counter visuals around the whole greenwashing campaign currently being held by the All England Club. So that might be something worth giving some thought to in terms of community action. I know many people will be here very capable of making their own photographs already. I've had a quick look at the Wimbledon website. Of course, it's great, but if there is anything that I can do, because I might be able to pick up on a language around the capability brown landscape, for example, a visual language around that. So if there's anything I can do, I will help. Just, I'm based in Surrey, and I have to confess, I'm not very mobile. I don't drive, I've never driven, and I don't have a car, so I can't offer to help everybody. But the other thing that might be of interest is that I run a course in photography at London College of Communication for undergraduate students. And if anybody thinks they've got a big enough campaign to formulate a live brief for students, that's something that we do once a year in the autumn term. So that might also be of interest to people. So keep all of that in mind. I know it's not your priority when you're campaigning. Your priority is obviously to keep the trees and to do everything possible. But if there's something that I can do to help in some way, that might be where we can have a conversation. Thank you.
That's brilliant. And what's a live brief? Is it like an online, is it almost like a kind of Zoom with a campaigner, or no?
So a live brief. So one of the problems that this is a kind of different issue, so forgive me for the explanation, but one of the issues facing arts education in the UK is that everything has to serve a purpose now. There can't be art for art's sake anymore. And so if you, as a UK student, if you have a student loan, then you are meant to serve some kind of purpose so that you can be gainfully employed and pay back your student loan. So there's some good in there somewhere, in the sense that actually, of course, if you do an arts degree, there should be some way of continuing to be creative after you have finished your course. But of course, it's all become about paying back the loan and arts being instrumentalized and so on, and perhaps even having a commercial art degree. And of course, for some arts, that's a really hard thing. So what we're trying to do in higher education is find opportunities for students not just to be creative and to grow their practice and to be really excellent at what they do, but to actually have an experience of working on a brief for other people. So it's a client-led experience. The students have the experience of working for somebody in particular, and hopefully that will make them more employable in the long run. Hope that makes sense.
Great, thank you. Julia,
I'll provide my contact details.
Yeah. That's great. Okay, thank you so much. Lovely to see you. So more updates, people. Valerie, I know you put your hand up earlier, and then would you, oh sorry, I know Ali as well as me actually, and Valerie, did you want to talk again, or?
I think you've heard quite a lot from Friends of St Matthew's Piece. I won't
right,
on your page.
The same group. Sorry, I get slightly confused.
Don't worry.
Okay, so I'm going to bring in Lawrence and then Ali, and then selfishly myself, and then probably someone else as well. So I don't know if I'm saying selfishly, because actually, yeah, I'm part of the group. Right, Lawrence, just as quick as you can, if possible.
Would someone else like to go before me? Because I'm nearly at Chester.
Okay.
And I'd love to have Chester in the background while I do my little 2 minutes of fame.
No,
That's okay.
no worries. Ali, do you want to come in here?
Yeah, I wouldn't normally push in, but I thought it might be nice for everyone to hear some reasonably good news, which we have had recently, sort of. So I don't know if everyone's aware about the campaign that I ran, but it was called Straw, Save the Trees of Our Modern Way, and we tried to save 100, well, so any number of trees essentially in the middle of Plymouth City Centre, and then in March 2023 the council cut them all down in the middle of the night, and it kind of made all the headlines, and it was quite big news for a while. And after that there were a couple of legal challenges which I brought against the council, and as part of that they sort of resolved to do an independent learning review, which was meant to be completed in February and was released about 2 weeks ago. And the panel were absolutely damning with regards to the council. And while we only saved a handful of trees, it's really sort of heartening now to know that virtually everything we were saying all the way through was vindicated. So they didn't consult properly. You know, the reports that the officers were sharing with the councillors were misleading. There's loads of stuff in there that, you know, it was literally everything we'd said all along and afterwards, you know, as part of the 2 legal challenges. So we had a judicial review and then a contempt of court case. And yeah, so that was really, really good. I mean, slightly on the downside is that we had the council meeting yesterday at which it was discussed, and, you know, lessons potentially not being learned as much as they could be. But, you know, there's ripples, and, you know, and certainly there's certainly been a change in the way I think people think about trees in Plymouth and how the public react. You know, they're not getting away with things like they used to. So yeah, bit of good news for everybody, sort of.
Thanks so much, Ali. And I'm so sorry I had to rush out while you were speaking. But we talk a lot, so that's fantastic. And yeah, it's been a really challenging time for you, and as a fellow female.
So, yeah, I mean, even yesterday, the new council leader basically, so the report sort of stated that the impact on the taxpayer for what happened was £3.3 million. And the new council leader basically implied that that was entirely my fault, like personally my fault. So pretty annoying, you know, especially since it really should have been a time for sort of reflection and apology. Even the new Tory bloke sort of made an unreserved apology, but the new Labour lot are slightly less grown up, shall we say.
Oh, sorry to hear that. Yeah, Labour seem to be intent on being really tough on nature, well, ruining it. I don't know why. Yeah, so Vasily, do you want to come in and then bring in
yeah, just very briefly. So I'm from the Bristol Tree Forum, and I guess the question that's often in my mind is when this kind of thing happens, and you know, some council does something terrible that it shouldn't have done. There seem to be no consequences. The same people just carry on as before, and there seems to be no way of ensuring any accountability of any kind. So you can't even get a proper apology. You can't get a commitment not to do it again. And so I'm kind of curious as to why councils can operate in that way.
Yeah. Well, I don't know. I mean, so interestingly, there was one recommendation from our council. It was a unanimous vote by the council to sort of install I think a Sheffield-style tree panel. So the council and the objectors, as we're known, could work closely together to try and stop it happening again in the future, rebuild trust, rah, rah, rah. But since then, the cabinet member for something, I presume the environment, has decided that we don't need that. The council have refused to reach out to us to apologise. The council, the chief executive of the council did apologise, but when she was asked whether she would take personal responsibility, she said there's a collective responsibility, which is really frustrating. I mean, the guy who was in charge of the department sort of scurried off last year. and the deputy chief executive is also retired. So yeah, I don't know. It's very difficult. That it seems to be virtually impossible to get any heads to roll for anything, and I would love to know what the answer is, but I haven't got it, unfortunately.
Yeah, I think collectively we all want heads to roll at different times, which happens in work. I'm just going to jump in here. Sorry, Janet, I can see your hand up. I'm just going to jump in quickly with my own update. As you may have seen an email yesterday, we're in the kind of last stages of trying to save this sort of test case plane tree on Oakfield Road, which we occupied for 8 months. We got loads of press on. The council covered it in a kind of totalitarian security operation for a week, 24 hour. I mean, it's crazy. They covered it in kind of tarp and had a watchtower in the, platform, loads of security guards. It cost them 92,000. Massive home goal. But at the moment, the important thing is there's a consultation at the moment, and according to, I think, the guidance, because I've asked our council, anyone, not only inside the borough, but anyone can respond to this consultation. And it's our borough's first public consult. They want to fell the tree, but they're doing the public duty to consult. We think it's the first one that they're doing. I don't remember any others. So it's a test case on many levels, but also the first time anyone, I have asked them, but anyone can respond. So I would urge you all to respond to this consultation, despite the fact it's not in your area. I've just put it in the chat. There's a really handy template on our website, which links you then to the Haringey Council website, and you can either fill in a form. There's some sort of points that we're trying to make, or you can email them directly. You have to give your information, like your name, address, the reference number. It's all quite self-explanatory. But we really want a lot of people to respond and to spread the word. And it's kind of like a collective, it's not just about this one tree. And that's the kind of main thrust of, this is a test case. This is in the insurance industry, pressuring, holding councils to ransom, holding residents to ransom. So that's what I would say. It's our last, we're at the last sort of stages of trying to save this tree. We're doing quite a lot of press. But yeah, if you could respond, that would be amazing. So if you want more details about the case, just get in touch with me. And yeah, that's great. So I'm going to go back to, so Janny, I know you had a quick point, and then I'm going to go back to Lawrence. You had your hand up.
Yeah, I just wanted to very quickly say that when we're talking about the council, it's on the one hand, we're talking about the councillors and the planning committee. On the other hand, we're talking about council officers. And that's a significant difference. In our case, at St. Matthew's Peace, it's the council officer who has validated the application time and time again. And actually, the councillors have rejected the planning applications again and again. So, I just want people to be clear, because of course the councillors are elected and they're going to be more responsive. And we have a very good community group that are, putting pressure on them. So people should be aware of that difference.
Yeah, absolutely. I totally agree. I mean, the council, we haven't found our councillors very responsive, unfortunately, like you have. The council officers really run the show at Haringey. So the head of parks, the head of the tree department, the officers are they've all been in the job 20 years. Yeah. They're the ones who are really running the show. I'm going to jump to Valerie and then Carrie, and then finally Chester.
Okay, my point is very brief. We've been running these campaigns every year now. This is actually our 5th year in a row. The first year was different from these 4. What we tend to do is we tend to do a substantial report from our group, from Friends of St. Matthew's Peace. And then in order to get the numbers up, which is what keeps the councillors motivated, is we tend to make it very easy for people to send in an objection, and they can just say, I agree with what I said last time, or we support Friends of St. Matthew's Peace. So we don't ask people to read lots of documents and write long objections. We say one sentence will do just fine. Is that what you're asking for us for Haringey, please? Or do you want us to write essays?
Well, I don't want you to write essays. There's a short page. It's not very, there's a few points that we make on our page, which are like 6 points. I mean, ideally you adapt or you do your own little, but it doesn't have to be really, really long. It could just literally be just how important trees are, or some, you know, data about trees or street trees. Yeah, I mean, there is a kind of template, not a template exactly, but a kind of guide that you can use to adapt. But obviously we don't want the same identikit emails going in. But it's quite the deadline is the 17th of June. Sorry, good idea. Sorry, thanks, Tamara. 17th of June. Sorry, it's been a really long day for me today. I've been up since 6 doing press related things, so I'm really tired if I'm a bit but that's a good point. That, yeah, I think if we have more of these, we will be coming up with a kind of standard kind of thing that people can respond with. But we would like it to be kind of meaningful as well, rather than just this kind of identikit, you know, email response, I think. But we have some really good points to make, and then there are other excellent points that I'm sure you could make. But obviously, if you're not, I mean, that's what our tree department have said. It's not just, they said that, well, they're a little bit unclear, but apparently anyone can consult. Okay, who was I going to? I was going to go to Carrie and then Lawrence.
Can you hear me? Thanks, Gio. Thanks, everybody. Another wonderful meeting. I'll be very, very quick. I put a note in the chat about thanking Ali for coming up and supporting us at the JR. So I won't repeat that again, but it was amazing of you, and thank you for your time. The judicial review went as well as it could. We expect a decision either this month or next month. I'm aware that lots of people, particularly those who are new to the group, won't have a clue what this is all about. But in essence, it's about a proposal by the Bristol Zoological Society to build flat soil over the old zoo site in Bristol, which we're challenging, and we hope to win. But if we don't win, we'll still keep fighting. The best place to look at if you want to know something more is on our website or on our X or Blue Sky account. And I wrote a little piece about reflections on the judicial review on there if anybody's interested. But thank you. That's it. Taken up enough time.
Thank you so much, Carrie, and well done on your brilliant campaign there.
Can I just really quickly say, if anybody wants to find any of the other member groups, they're all on the Canopy website. So if you're having trouble finding another group, so Carrie's group is on there, and everyone's got a little box, and it just links out to the website or the Facebook page, or whatever's most useful. So
brilliant. Thank you so much. Lawrence?
Yeah, hi. Sorry, I've been engaged. I've been quoting for TfL and also starting to work for Network Rail this week. So I know how that's probably going to look. But this is Chester, by the way. So this is our tree, our campaign. One of the cool things that we've done since we last spoke is raise a children's book. So Katie can't unfortunately be at the meeting, but she's written and had wonderful artwork done about the tree. It's a child's book, and I'm sure she'll be able to send over links. But yeah, this is our tree. This is our tree, and the reason it needs to be felled is because it's unsafe. However, we've proved that the tree is safe, and the issue is actually that the this area here isn't wide enough for a disabled access. We've noted that that's a raised ironwork put in by the council, and therefore, you know, what's your views? Why do we take the tree out? Because we can't have access. And then we go to this 330 mil away from that raised brick pier, which was recessed just like this. So therefore, the council has approved that site hoarding to be outside the development land, thus cutting in to the available land that is available for access. This this left-hand lane here doesn't get used for turning left. It goes straight on because it's only a narrow one-way road. So that's what we're fighting against, and that's our tree. So the updates really is it's so nice to actually be able to see the tree this time of year in leaf and have you all see it. Katie, myself and Tim are the instrumental group behind Save Chester. There are other tree campaigns in Southend has raised a book. What's there other updates?
It's shocking to me that why developers and planners wouldn't see it as a positive thing to keep a beautiful tree like next to their
100%. So that's why we that's why we've attacked the common ground. So we were lucky enough to, as I say, for Casey to write a book. We've been in Essential Arb. We've been now in The Guardian, actually, because we employed a human rights barrister. And the I newspaper ran a campaign, national campaign, Freedom of Information Act, which started by my good friend. Well, we all call him Campo, but yeah, he approached every single council to ask how many trees are you felling. You know, trying to get answers. I mean, we both know they want to put a 14-story building here, and there's a tree there, and that's going to cost them a hell of a lot. Now, the caveat value on that tree was $5,000, and we put it in at like 73. You know, there's just not a there's no visibility there. Like, just prune the tree because obviously they haven't done it. However, the tree is deemed unsafe by the local authority. Yeah, the bus has hit it, but it just needs to lift and a prune and everything like that. Anyway, moving very quickly on, because we have raised so much awareness, I believe, on the national print media. We went to the Ancient Tree Forum, and this is now logged as a veteran tree. You know, it's potentially going to be a veteran tree. It doesn't matter about its age. It doesn't matter about its characteristics. It's
Lawrence,
significant.
can I just ask? You said it's been logged, but has it been accepted? Because I thought
I believe so. Yeah.
Right. Okay.
Yeah.
I'm going to have to stop you there because we're coming to the end of the meeting now. But thank you very much. It's lovely to see a wonderful tree, and we really hope the campaign works. And obviously, Julie's been really involved as well at the beginning with the Chester campaign. So she's not here tonight, but it's fantastic. And it's a really high-profile tree. We really hope it's saved.
May I just add finally, myself and Henry helped out on the other tree that we've supported. We've both done our PTIs, so we are looking at helping out other tree campaigners if they want a professional tree inspection.
Okay.
Just gonna do it like pro bono.
Okay,
like that, if we can
great.
help.
That's brilliant. I'm going to have to stop you. I'm so sorry. It's just time.
Cool, no worries.
I mean, thank you very much. So that brings us to the end of the meeting. Is recorded and the notes. Ali, have you been doing sort of notes on? Fantastic, which is amazing considering it's a 2-hour meeting. There's so much detail. I think the chat, yeah, the chat is shared. Does the chat download into the notes as well? Because there were loads of really good.
I put a little bit in. Yeah, I don't.
Okay, that's really good. Our next meeting is going to be on July the 2nd. Is it? Hang on, let me just check. It's going to be on. No, it's going to be on.
Yeah,
1st of July. We're going to have Greg Packman at that meeting. He's a very good, well-respected sort of arb and tree guy, and he'll be talking for half an hour on the probably much more kind of beautiful kind of. I'm hoping something a bit more kind of positive than thinking about subsidence, which I know is not the most riveting. Although I know too much about subsidence, I think. But yeah, it's going to be on, hopefully he's worked with Big Canopy and amazing trees all over the world really now. So he's great. He's really good. I'll send a little bio out of his. And yeah, just keep us posted. So again, like I've done with my campaign, if you have any particular, pressing needs for your campaign and you desperately need some more support, just send a message to us at Canopy and we can send out an SOS. So, thinking about that and keeping us posted. Also sharing tips, like, it'd be really nice for us to have maybe on the website, you know, FAQs and tips and what to do if and what we've learnt. So I don't know if they're, you know, if any groups can do like nice little punchy summaries of things they've learnt about their during their tree campaigns that might be useful for other groups.
We've also got a WhatsApp group, which
Yeah.
I think most people know about because we're useless. But if anybody would like to join the WhatsApp group, email me your phone number and I'll put you in it.
Yeah, it's a
good
great
way of sharing tips as well.
Yeah, you can get really quick answers to things because people are all tree nerds like us. So yeah, do let us know. So anyway, lovely to see everyone, and I will be in touch. We will be in touch soon with more stuff and the recording to share. Okay, all right. Cheers.
Thanks, everyone.
Thanks so much. Take care. All right. Bye.